Good morning again. This is Dan Reel with Fraudclosure 101, and today we're going to talk about motions to strike. Now, if you look at Connecticut Practice Book 10-39, the 2015 version, this really hasn't changed substantially over the years, and foreseeably it won't, but you should still nonetheless check. And again, this isn't legal advice. This is just for educational, informational purposes. Always talk to an attorney and always run it by an attorney. This is a fairly common pleading, and it has primarily four usages. First, to challenge the legal sufficiency of a pleading. For example, say a complaint, cross-complaint, counterclaim, or special defense isn't legally sufficient. You would use a motion to strike to challenge that pleading, and you would outline why it isn't legally sufficient and what the different sufficiencies are. Non-joinder of essential parties. This is also a critical, especially in foreclosure cases, uses of a motion to strike. What happens in a lot of situations is throughout the whole securitized mortgage process, you have various bankruptcies that occur with the originators. You have various parties of interest that perhaps the plaintiff forgot to name on the land records. Because typically when you're dealing with fraud closure mills, they like to do this really fast. They want to boost you from your home right now. So along the way, they kind of miss things. Sometimes you will also see they've named improper parties to the complaint, and a motion to strike is actually also used to address misjoinder of parties. Now, misjoinder is defined as, when a party has been included and they're not an essential party. Now, you also want to look at Practice Book 11-3, which says the exclusive remedy for misjoinder is a motion to strike set forth in Practice Book 10-39. Finally, the other use of a motion to strike is when the plaintiff combines two or more causes of action improperly in a complaint that cannot be joined. I would say, hypothetical example, let's just say the plaintiff is alleging foreclosure, but they also allege in the same complaint that you drove a car through the bank's headquarters and you injured the vice president. Obviously, that'd be such a stretch it would never happen, but just to illustrate for practical purposes, you would use a motion to strike for that. As always, consult an attorney. This isn't legal advice. This is just to help point you in the right direction. Perhaps get the juices flowing for the discussions that you should be having with your attorney. And most importantly, there are a lot of reasons to always check the land records. One of them is to make sure that you absolutely don't need to file a motion to strike. So I hope this video was helpful. Check out our other videos on our YouTube channel, Fraudclosure 101. Questions, comments, shoot us an email at headlinecopy@gmail.com. And we hope to get a better microphone soon, which we will. And if you have any other ideas for a video, let us know. We'll be happy to put one up. Take it easy, best of luck, and happy hunting.